This MBL webinar is designed to bring you up to date on two topics. The first one is non-court dispute resolution, NCDR, and the second one is costs. And I do them together because they're often interrelated, as you will all know by now, that if you do not engage in non-court dispute resolution, it is likely to have an impact on a cost outcome. These are hot topics. They were hot topics when I started giving this talk, these MBL webinars on this subject in 2021, 2022. In fact, I updated it in 2024. And 2026, 2 years later, they're still hot subjects, and there are still legal changes being made, particularly in relation to the rules dominating the NCDR. It used to be known as ADR, more alternative dispute resolution, but more commonly I notice it's called non-court dispute resolution, which is a bit of a mouthful really. And the emphasis continues on trying to resolve matters outside court. There have been rule changes since 2024 when I gave the last talk, and there's quite a lot of fairly recent case law which I'm going to cover in this, as the courts continue to place even greater emphasis on NCDR. Why is this? In part, it's cheaper, it's far less conflictual, and another reason is because the court system is struggling. It's struggling to cope, and cases are being routed into a private system of resolution. I'm just going to touch on the different kinds of NCDR before we get into the main meat of this talk. Mediation, that's the classic alternative dispute resolution, alternative to the court system. It's a different way of resolving issues. It has a good success rate, and I would highly recommend it. And the MIAM, the Mediation Information Assessment Meeting, is part of the court's encouragement of that process.